everybody, this is Eric Jose on Making a Murderer on YouTube. I cover the Stephen Avery and Brendan Dassey cases, but also as time passes, I've been covering other cases such as the Staircase or OJ and many wrongful convictions of youth. I go over the documents, the photos, the videos, anything case related. So stay tuned because I have many more videos just like the one you're about to see. Hello there, ladies and gents. Okay, here we are with the somewhat long-awaited here, covering the ineffective assistance of counsel section of the motion for post-conviction relief. MPCR is what we call it for short, for those of you who may have heard that term and weren't sure what it means. So, that's what we're covering today. Today is going to be part one of ineffective assistance of counsel. It's a very long section. It's, like I said, 100 pages, a little over 100 pages. It's the biggest section in there. So we're going to be going through the first part of it today. Today, Travis couldn't be here to film the slideshow and the going over the slideshow. So we got Tracie Stransky to step in and pitch hit for Travis. So for those of you who loves Tracie as much as I do and even Travis does, you'll be pleased to hear her kind of chime in here and there on the slideshow here. So basically we're going to go over what she's arguing and what she feels was the ineffective assistance of counsel by Dean and Jerry. She goes a little bit into explaining what constitutes ineffective assistance of counsel according to the Wisconsin case law kind of stuff. And so she got this is the beginning, basically, like I said, part one of ineffective assistance of counsel. We will be putting up part two most likely tomorrow. And then following it with a live. Who knows, we may get the decision from the Court of Appeals tomorrow as well, so we'll have to see how this all works out. But that's where we're at. So we'll go ahead and get into it right now. Part one with Tracie Stransky stepping in, pitch hitting for Travis Williamson, and away we go. Okay, hello everybody. How you doing today? We're here with the long-awaited MPCR, ineffective assistance of counsel section. We've had a devil of a time with this section because this is actually the biggest section in the motion for post-conviction relief. It's like 100 pages, a lot of things that it goes over. We had to break it up into multiple videos. So what this is going to cover is basically what Kathleen Zellner thinks Dean and Jerry could have done that would have, helped Stephen's case. That she's gonna have the opinion that they dropped the ball on all this stuff. And therefore, it's ineffective assistance of counsel that allowed the prosecution to put forth the narrative that they put forth in this, and it wasn't challenged vigorously enough by Dean and Jerry is essentially what she's getting at. One thing I want to point out, and you guys may have heard Travis say this before, I don't necessarily want everybody taking a negative view of Dean and Jerry here, because as Travis said himself, defense attorneys in this type of situation, when a former client gets a new attorney and is seeking post-conviction relief, they have an attitude of basically like that they're willing to fall on their own sword to go ahead and help their client, their former client. So long as it's not something egregious that's going to get them into serious hot water, where they did something unethical and against the law. But if it's just ineffective, like they missed something or whatever, they're willing to just fall on their sword and say, yeah, my bad, we did that badly, that's we were ineffective in that sense. And they do it willingly because they know it's a necessary part of the post-conviction process. It's one of the few tools that a lawyer has in their tool chest in the to use an analogy, in the post-conviction realm, as it were. So that's one of these defense lawyers understand that, and to a certain extent are willing to just fall on their own sword and say, yeah, that was my bad, and take the blame. So knowing that, just realize Dean and Jerry, they did a lot. They did the best they could. They had limited resources. They certainly didn't have the resources that Kathleen Zellner has. So you take it with a grain of salt. But this is the ineffective assistance of counsel section. All right, so let's move to the next slide, Julie. Okay, so remembering from the last couple slideshows that we did, I know it's been a while, sorry. But remember, if you have questions here, and this, it may be more important in this section more than the previous sections. If you have a question about something, remember the slide number and remember the paragraph number. That way, when we do the live tomorrow night, you will be able to point to exactly what you're asking us about more effectively, and we will be able to, because you'll be able to point to a specific slide and paragraph, we will be able to more accurately, you know, understand what you're asking and better answer your question. So just remember to remember the slide number, and all the paragraphs you're going to see here, all the bullet points are all going to have a paragraph number. So just remember the paragraph number and the slide number, and that'll help us to answer your questions tomorrow night in the live. Okay, so the next slide, Julie. Okay, so applicable law regarding ineffective assistance of counsel. That's going to be the first thing we go through here, where it's going to go through. Kathleen Zellner basically goes through the applicable law in terms of ineffective assistance of counsel. So next slide. Okay, so we start out in this section at paragraph 93. A defendant alleging ineffective assistance of counsel first must show that the counsel's representation fell below an objective standard of reasonableness. It is not necessary to demonstrate total incompetence of counsel, and the defendant makes no such claim here. Rather, a claim serious enough, a single serious error may justify reversal. The deficiency prong of the Strickland test is met when the counsel's errors were the result of oversight rather than a reasoned defense strategy. So, to get what they're saying, what she's saying at the end there, it's the deficiency prong of Strickland test is met when the counsel's errors are a result of oversight instead of a reasoned defense strategy. Basically, if Dean and Jerry had reasoned that the best strategy was to avoid a certain topic, then basically Zellner would have trouble trying to raise that now. Because by their reasoned strategy, they chose to abandon it essentially. So if she were to try to pick it up now, that would not be because they didn't realize it before. It would be because it was their reasoned strategy, and therefore it would be very difficult for her to try to raise. So that's what that's basically getting at the end of there. Would you agree with that, Tracie?
Yeah, and as an example, this has already happened with the issue with the CD on the last remand, because the defense argued that the state argued that the defense went with the whole planting defense and the blood vial, and they tried to say that's why they didn't explore the computer or didn't want to look at the computer, because it was their strategy to use a planting defense. So they're already trying to use that as an argument against IAC.
Okay, so there you go. So yeah, so that's a perfect example. Okay, so well said. Okay, so moving on to paragraph 94. Second, a defendant generally must show that the counsel's deficient performance prejudiced his defense. The defendant is not required under Strickland to show that the counsel's deficient conduct more likely than altered the outcome of the case. So basically, if whatever they missed, if whatever his trial defense counsel missed, most likely would have had a significant, outcome, or a bearing on the case, or would have likely altered the outcome of the case, then it's relevant. Reasonable probability under this standard is defined as probability sufficient to undermine confidence in the outcome. So that, like Travis has said many times, who isn't here tonight unfortunately, but like he said many times, undermining confidence in the verdict. That's what it's all about in post-conviction, undermining confidence in the verdict. That's the mantra, remember. So if this test is satisfied, relief is required. No supplemental abstract inquiry into fairness of the proceedings is permissible. You have anything you want to add on that, Trace?
Let's see.
Number
no,
95?
Not really. I mean, it's pretty straightforward.
Okay. To prove prejudice, the defendant must show that counsel's errors were so serious as to deprive the defendant of a fair trial, a trial whose result is reliable. That's interesting wording. So, moving on to the next slide, please. Okay, trial counsel's failure to call experts and thoroughly investigate. Paragraph 97, trial defense counsel tried to combat the state's 14 experts merely by using cross-examination without their own experts in blood spatter, DNA, forensic pathology, ballistics, and forensic fire analysis. Trial defense counsel could have conclusively demonstrated that Miss Halbach's other bones had been planted in Mr. Avery's burn pit. Trial defense counsel failed to thoroughly investigate other suspects and instead chose a scattergun approach to simply naming individuals without meeting the requirements of State versus Denny. That's obviously criticism that they didn't dig into the computer, you know, obviously. But I don't know. You guys know how I feel about that. They were jammed up with the computer, and the CD was held back so that they wouldn't know what was there. All sinister happenings around that computer. But obviously, you know, she's gonna attack everything. Like Travis said at one point, obviously, that she's gonna put everything in that she can, anything she thinks that can possibly stick, because she only needs 1 or 2 or 3 to actually stick. And I actually made a joke with Travis about this, saying, well, it sounds kind of like the prosecution's approach to prosecuting somebody. They pack on as many charges as possible, and then that way, to win, they just need one of those many things to stick. And so Zellner has to take a similar attitude in this, which I think is cool, because in this case, I like seeing the tables get turned on the state and the prosecution. So I kind of dig that aspect of it. Anyway, sorry. Next slide. Okay, applicable law regarding the duty to investigate and to present expert testimony. Counsel has a duty to conduct reasonable investigation or to make a reasonable decision that makes particular investigations unnecessary. Consistent with this obligation, Strickland typically demands that counsel go beyond the discovery provided by the state and conduct his or her own pretrial investigation. Thus, there are times where the only adequate means of challenging expert testimony elicited by the state is to introduce contrary expert testimony in favor of the defense. Moreover, the failure to investigate an expert where an expert witness's opinion is crucial to the defense theory constitutes ineffective assistance of counsel. Any thoughts, Tracie?
This is all falls under, I just said before, I said that I read extensively State versus Thiel, and this all is what falls under that case law. And it's been clearly established under that they have a duty to investigate. They have a duty to do their due diligence when it comes to discovery and reading all the materials. And so, yeah, that pretty much just covers it. But yeah, the case law supports all that.
Okay. So that's, yeah. So that's why she brings this up, because the case law supports it. Right. So next slide, Julie. Okay. Paragraph 108. Likewise, in Thomas v. Clements, the defendant was convicted of intentionally strangling the victim to death. The defendant's defense was that he unintentionally caused the victim's death by putting too much pressure on her neck for too long during sex. The medical examiner testified that the hemorrhages in the victim's eyes and abrasions to her face indicated that the pressure applied to her neck occurred during an assault and was intentional. Paragraph 109. Following his conviction and the denial of his post-conviction petition, the defendant filed petition for writ of habeas corpus. Specifically, the defendant alleged that his trial attorney was ineffective for failing to consult with a medical expert to review the medical examiner's findings. The Seventh Circuit held that the trial counsel's failure to even consider contacting a pathologist to review or challenge the medical examiner's findings constituted ineffective assistance of counsel. Specifically, counsel knew that his client claimed that the death was unintentional and that there were no signs of a struggle. So, in this case, the gentleman involved was having sex with his girlfriend, who apparently was into the whole strangulation thing. And apparently it got a little too involved, and she actually ended up strangled to death. So what happened here is he tells his counsel this, and his counsel basically just didn't listen to him, didn't look into it, didn't bring in any kind of experts to try to back up his story at all. And so when he went into his habeas proceedings, he was able to point to that. And that was basically ineffective assistance of counsel. His lawyer dropped the ball on that, point. and so he was able to get relief that way. So that's, you know, because they were able, you know, that's basically ineffective assistance of counsel, because you're bringing in that kind of an expert to combat the other expert for the state. Now, obviously, does everybody always have the money to bring in these kind of experts? Well, that's one of the other hurdles we have in our current criminal justice system. But, you know, still, this is one of the ways that you can get relief, and so that's why it's put into the motion here. So let's move to the next slide.
I just want to say something about that quick.
Go
there
ahead.
there actually is a case that was decided by the Wisconsin Court of Appeals just this last summer, which is a more recent case, obviously, than Clemens, the one that she cited, where it's an IAC claim for pretty much the same reason exactly. Almost the circumstances are almost exactly the same. The state had presented a medical examiner at trial. The defense didn't present any competing witness, expert witness, or expert testimony. After it was a female woman. It was a female woman, a woman named Marsha Render. She found a medical examiner after, you know, post conviction to say, hey, I don't agree with these results. And the Court of Appeals decided that, yes, she should be allowed to present this competing expert's opinion, and that they should hold a Machner hearing on the IAC claim. So a Machner hearing is just an evidentiary hearing for IAC. So under that alone, that should show that if at the very least, that situation, with Steve's case, should require a hearing.
Right.
At the very least, because at least that more recent decision even says that.
Right. Absolutely. Okay. So let's move now to the next slide, Julie. Okay. In yet another case, the Court of Criminal Appeals held that the failure to challenge the state's testimony concerning blood spatter constituted ineffective assistance of counsel. The court held that defense counsel's failure to challenge the state's witness testimony by presenting contradictory expert testimony qualified as ineffective assistance of counsel. Several cases in Wisconsin likewise hold that the failure to investigate and or call expert witnesses to discredit the state's case and or to support the defendant's theory constitute ineffective assistance of counsel. So it looks like it's well established that failing to call in the proper experts to combat the prosecution's testimony is one of the ways that I think what this is suggesting is that it's one of the ways that most or often finds success in post-conviction, I would say, is what that's suggesting. Would you agree with that, Tracie?
Well, I wouldn't say it's mostly, you know, the best way to get relief from this, but it's definitely well established that especially when it's a situation like they said in Clemens and like I just mentioned in Render, where the biggest claim or the biggest thing that probably convicted you was this one expert's testimony. If a lot hinged on that, then defense counsel has an obligation to try to refute that testimony.
Sure.
So if there was a lot of different experts, maybe they won't pinpoint one being more important than the other. But when it's a case of you have one person's testimony, basically buries your client. You have a duty to try to find a witness that can contradict what they're saying. And it will rise to being an effective assistance of counsel if you don't do that.
Right. Okay. All right. So moving on to the next slide, Julie. Okay. Failure of trial defense counsel to investigate Mr. Avery's claim that his blood was removed from his bathroom sink and planted into the RAV4. So this is gonna be about that. Obviously, the blood in the bathroom sink and the fact that Dean and Jerry never even really listened to Steve about it. So let's move to the next slide. All right. On the evening of November 3rd, 2005, Mr. Avery was having dinner at his mother's house, and when he walked outside of her residence, an ununiformed officer pulled up in an MCSD squad car and asked if he could speak with him. Later, Mr. Avery learned that this individual's name was Sergeant Colburn. Mr. Avery told Sergeant Colburn that he noticed her photographing the van, and he exited his trailer to pay her. Mr. Avery observed Miss Halbach leave the property and turn left onto Highway 147. Sergeant Colburn misrepresented in a report written months later that Mr. Avery said 3 p.m., not 2:30 p.m. Mr. Avery's affidavit is consistent with all of his prior statements. Mr. Avery then drove his Pontiac Grand Am from his parents' residence to its usual parking spot in front of his garage. Mr. Avery then walked next door to his sister's trailer, where he attempted to unhitch the trailer. In so doing, Mr. Avery broke open the cut on his middle finger of his right hand. Mr. Avery dripped blood onto the rim in the basin of his sink and the bathroom floor. He did not wash away or wipe up the floor or sink because his brother Charles Avery, Chuck, was waiting for him to go to Menards in Manitowoc with him. Bloodstains were noted on the molding and the inside of the living room door of Avery's trailer, Mr. Avery's trailer. So that just gives further evidence that he was bleeding, as he's saying, or at least giving some credence to that of what he's saying, because they were finding his blood in other spots. Makes sense. Next slide, please. Mr. Raleigh Johnson, a family friend of the Averys and owner of Mr. Avery's trailer, remembers observing the cut on Mr. Avery's finger at least 1 week prior to October 31st of 2005. At approximately 7:30 p.m., Mr. Avery was exiting the Avery property onto Highway 147 when he observed taillights of a vehicle close to the front of his trailer. Mr. Avery contends that the only way the vehicle could enter his property from the direction it was pointed was if it had driven by the way of Cuss Road and then come across the field to the front of his trailer. Mr. Avery believes the vehicle's taillights were similar to those of the RAV4 and not a squad car. Mr. Avery instructed his brother Chuck to turn around and drive back to the trailer, but by the time they drove back to Mr. Avery's trailer, the vehicle had departed into the darkness. This is all Kathleen Zellner's theory, by the way, folks, so that's what we're going through here. Jump in anytime if you have something to say, Tracie.
Okay.
On November 4th, 2005, Mr. Avery awoke at his normal time of 6 a.m. When he entered the bathroom of his trailer to take a shower, he observed that most of the blood in and around the sink had been removed. Mr. Avery consistently expressed his belief to his attorneys and the media that the blood found in Miss Halbach's vehicle was planted and that it came from his trailer. Next slide, please. Okay. At 10:30 a.m. on November 4th, 2005, Lieutenant Link and Detective Remaker arrived at the Avery property to interview Mr. Avery. In the early evening, Mr. Avery smelled cigarette smoke when he entered his bedroom to retrieve a cable for his mother's television. Neither Mr. Avery nor his girlfriend smoked. So that's an interesting little tidbit, folks. Stephen and Jody didn't smoke. So smelling smoke in Stephen's trailer is interesting. On November 5th of 2005, when Mr. Avery was preparing to leave for a trip to the family property in Crivets, he noticed the south front door of his trailer had been pried open. Mr. Avery's brother Chuck left for Crivets. He observed headlights in the area where Miss Halbach's vehicle was discovered by the pond. Chuck called Mr. Avery at 7:20 p.m. to check on the headlights, but by the time Mr. Avery arrived by Chuck's trailer, the lights were gone. Next slide. Okay, so trial defense counsel's failure to present a DNA expert's opinion about blood being planted in the RAV4. That's where Stuart James comes in, of course. On November 7th of 2005, the Wisconsin State Crime Lab discovered small drops of blood in the front of Miss Halbach's vehicle on the driver and passenger seats, driver's floor, and rear passenger door jamb. Suspiciously, there were no bloody fingerprints of Mr. Avery in or on the vehicle, despite the fact that he could not have been wearing gloves when he allegedly deposited the blood from the cut on his finger in the vehicle, right? And this is basically just saying that the defense was not coming up with enough experts to combat the state, obviously. Next slide, please. Applicable law regarding the admissibility of conducting experiments and recreations. The admissibility of experts and recreations to support and illustrate an expert's opinions is well established. Pretrial experiments may be admitted into evidence if there is probative value and it is not substantially outweighed by prejudice, confusion, and a waste of time. Any thoughts on that, Tracie? Oh. Next slide, please. Oh, there we go. Failure.
Sorry, I had my mic muted. Sorry.
I noticed. Yeah, I noticed. I
Yeah, because
figured
my
you were
dog
busy.
was barking, so I didn't want to. Sorry, I
Oh,
was saying that we did talk about that in an earlier video where we talked about the procedure for doing any type of experiments during the trial or
right.
anything like that. So yeah, so it's something that they should have at least looked into.
Certainly.
Yeah,
I mean, look at how everybody's calling for a recreation of the key. I mean, the Colburn's little fantasy. I mean, everybody wants a recreation of that. So
right.
you got to imagine that was a huge ball drop there. Okay, so failure of trial defense counsel to present a blood spatter expert who had conducted experiments which demonstrated that Mr. Avery's blood was planted in the RAV4. Zellner has hired Mr. James, a renowned blood spatter expert who has examined all of the relevant blood spatter evidence produced in discovery to the trial defense counsel. Mr. James, based upon the experiments that he oversaw, opines that blood spatter found in the RAV4 was selectively planted because the experiments demonstrated that if the state's theory that Mr. Avery was actively bleeding from the cut on his right middle finger was true, then blood would have been deposited in many more places in the RAV4 than where it was deposited. Right? So what that means, folks, it should have been on the steering wheel, should have been on the transmission shifter, should have been all around. It should have been like all around where you would turn the key. I mean, how it doesn't end up all around where you turn the key, but it ends up 3.5 inches away, looking like it was put on with a Q-tip. Well, that just tells you that it's planted. But anyways, so, we got all these, the fact that it's not in the places it should be. Obviously, he's opening the hood. We got 1.9 nanograms of DNA on the hood latch, but it's not blood. It was ruled out that it wasn't blood. I mean, it's just all the things that don't quite match up when it comes to this blood and stuff. So anyway, that's what Mr. James is getting at. Next slide, please. Okay, the blood spatter experiments conducted with actual blood on the subject's middle finger conclusively demonstrate that the blood would have been deposited on the RAV4's outside door handle, key ring, steering wheel, gear shift, lever, brake, battery cables, hood prop, right? Just as I was saying. Mr. James oversaw experiments that conclusively refute Mr. Kratz's argument that the sheer volume, the sheer number of places, rule out the blood in the RAV4 was planted. Mr. James opines that the blood flakes detected on the carpet of the RAV4 were planted because experiments demonstrated that blood dripped onto the RAV4 carpeting would be absorbed into the carpet and would not form flakes on the carpet. Okay? So that's going to be an interesting one to obviously see recreated, because obviously the blood flakes being found in the RAV4 are probably the biggest reason why I feel the blood in the RAV4 is planted. So, Mr. James opines that the most likely source of Mr. Avery's planted blood was the blood deposited by Mr. Avery in his sink on November 3rd of 2005 and not the blood from the 1996 blood vial. Okay, next slide. Failure of trial defense counsel to present a blood spatter expert who had conducted experiments which refuted the state's blood spatter expert's opinion about cause of the blood spatter on the rear cargo door of the RAV4. Boy, that's a lot of words to say. Mr. James wants to say that the state's blood spatter expert is full of crap as to how the blood spatter got on the interior of the cargo door. So, Mr. James opines that the blood spatter on the inside of the rear cargo door was the result of Miss Hallbox being struck with an object consistent with a hammer or a mallet while she was lying on the ground at the back of the vehicle after the rear cargo door was open. So, if you guys know, that door swings open. It swings open and goes basically parallel with the passenger side of the car. So it's like, if you imagine the whole entire... So it swings out and goes completely parallel with the passenger side of the car. So what they're saying is that the spatter looks like she was on the ground, prone on the ground, and somebody was hitting her in the head with this mallet and swinging it backwards towards the interior of that door. And that's how that blood spatter got there. I believe they go over now. Mr. James opines that the state expert, Mr. Stalkey, mistakenly described the blood on the rear cargo door as having been projected from Miss Hallbox's bloodied hair after she had been shot as she was thrown into the cargo area of the vehicle. So what Mr. James is saying is that the state's expert's the state's expert's trying to say that as they were tossing Teresa into the back of the RAV4. And by the way, it's very difficult to just toss a limp human body. By the way, it's not an easy thing to do. And then somehow that blood flung off of her hair and flung onto that interior door. So that's just how ridiculous that is. So that's why I bring that up. Okay. Mr. James, by overseeing a series of experiments, opines that the state's description of the cause of the blood spatter on the rear cargo door resulting from Miss Halbach's being thrown into the cargo area and blood being projected from her bloodied hair onto the cargo door is demonstrably false. I do love that word, demonstrably. Anyways, the erroneous blood spatter testimony of the state's expert, Mr. Stalky, resulted in the state presenting a false narrative to the jury about the sequence of events surrounding the attack on Miss Halbach. Any thoughts, Tracie?
No.
All right, next slide, please. Failure of trial defense counsel because of not having a blood spatter expert to recognize the 1996 blood vial was not the source of blood in the RAV4. Mr. Avery's trial defense counsel were unaware of the EDTA preserved whole blood sample stored in the Manitowoc County Court of Clerk's office until the summer of 2006. Prior to that time, the trial defense counsel failed to develop a credible explanation for the presence of Mr. Avery's blood in the RAV4. Mr. Avery's trial defense counsel relied exclusively upon a frame-up theory of defense, correctly arguing that all the evidence inculpating Mr. Avery was fabricated. However, they incorrectly argued that Mr. Avery's blood found in Miss Halbach's vehicle was planted by law enforcement and that it came from a 1996 blood vial held in the clerk's office. Trial defense counsel's theory about the 1996 blood vial was carelessly constructed without corroboration. Next slide. Failure of trial defense counsel to demonstrate to the jury that Miss Halbach's key was planted in Mr. Avery's bedroom. I do love that meme. I made that with the help of Carrie Mindel as a very funny night when we were making that. Anyway, sorry. During the November 8th search of Mr. Avery's bedroom, Sergeant Colburn conducted an hour-long search of Mr. Avery's small bookcase. An hour long with that tiny little bookcase, which was approximately 32 by 16 by 31 inches. Sergeant Colburn testified that he tipped and twisted the bookcase, pulling it away from the wall. He proceeded to remove all the bookcase contents, examine them, and put the items back into the bookcase, but did not observe the key in the bookcase. That's because it was in Narnia. That's why. Anyways, it hadn't popped out of Narnia yet. That's why. The key was not present in the initial photographs of the bookcase, and Mr. Avery's slippers during Sergeant Colburn's frenetic interaction with the bookcase. Lieutenant Link left the bedroom. When Lieutenant Link returned, he noticed a Toyota key had suddenly appeared. Prior to the key's discovery, Lieutenant Link reportedly picked up the slippers and set them back down after checking within and under them while searching Mr. Avery's bedroom on November 8th of 2005. Neither side subpoenaed Mr. Avery's bookcase to the trial. Trial defense counsel's failure to have the bookcase at trial to demonstrate the impossibility of the state's story about the discovery of the key was a fatal error. A simple experiment with the bookcase and Toyota key would have conclusively demonstrated that the key was planted next to the bookcase by Sergeant Colburn and Lieutenant Link. Conclusive proof that this is one piece of evidence that was planted and would have collapsed the state's house of fabricating evidence. Okay, so I'm going to point out a couple things here. Number one, Zellner's office has done their own cabinet experiment. I believe you can find it on YouTube. I believe Zellner has their own YouTube channel now. I believe it's there. Also, I have my video where I bought a bookcase that was very similar in proportion and shape and build to the one that was in Steven's room, and I conducted my own experiment, and I'm telling you that Colburn is completely full of it. That's why I choose to make him sound even more ridiculous by saying that the key popped out of Narnia. The aliens were kicking it in Narnia, and then they just tossed it out there, you know, at the right time. Anyways, and then the other thing I want to bring up is Zellner's recent 10-day challenge to Colburn, where She extended him the invitation to come on down to her offices. They have the cabinet, or one that's approximately like it, and he can show them exactly how it was done and how it happened. And then he could put all this to rest. Well, he didn't take her up on it. All right, next slide. Okay, failure of trial defense counsel to investigate and demonstrate that the planted Toyota key was a sub key and not a master key, as Mr. Kratz claimed. Kratz needed the jury to believe that was Teresa's everyday key. If it were a spare key, that would suggest planting. The photograph of Teresa holding multiple keys obviously is another, indicator that it wasn't the real key, because where are all the other keys that are on her key ring that we see in that one picture? The new media crew interviews with Blodorn, and there appears to be a RAV4 key on the kitchen counter. Some of you may have seen Ripper did a video about that recently. If you haven't, go over to Ripper's channel and check it out. I think it's probably the second to last video he did, where he is questioning that very thing himself. Next slide, please. Failure of trial defense counsel to present a trace expert to establish that the key planted in Mr. Avery's residence was not a key Miss Halbach used every day, making it more probable it was planted. Next slide. Okay, so Dr. Palahniuk examined the Toyota subkey. Dr. Palahniuk is a guy over at Microtrace, folks, if you don't know. He's the guy with the really powerful microscopes. He's the guy that found the bits of paint and wood in the item FL. Okay, Dr. Palahniuk examined the Toyota subkey recovered in Mr. Avery's bedroom. Dr. Palahniuk concluded that the subkey recovered from Mr. Avery's bedroom is demonstrably not the master key that Miss Halbach used on a daily basis, because the shape of the key recovered from Mr. Avery's bedroom, item C, corresponds closely to the shape of the subkey illustrated in the 1999 Toyota RAV4 owner's manual. The key recovered from Mr. Avery's bedroom is different from the key seen in the victim's hand in the trial exhibit 5. The subkey, item C, and the debris adhering to it were microscopically examined. Wear patterns on surfaces of the subkey that made contact with the locks and ignition show evidence that the subkey had been utilized since the deposits of fine debris in the subkey grooves occurred. Furthermore, the relative amount of the debris on the subkey grooves was compared to 5 exemplar vehicle keys that are utilized on a daily basis, including one from a 2012 Toyota RAV4. While the amount of debris on the key can vary due to a number of circumstances, the general quantity of debris on a recovered subkey, item C, is greater than any of the 65 exemplar keys that were examined. So to get at what they're trying to say here, and I know it maybe isn't quite clear, what they're saying is that the key that is in evidence has a level of like dust and debris that's actually sticking to the actual metal part of the key. 155 is saying that you can see that slight amount of debris that's on the surface has been pushed aside or has been moved around because the key has actually been pushed into a lock to unlock the car, or has been pushed into the ignition to manipulate the ignition. So there are places where the fine dust and debris that's collected on the key have been pushed aside. The second paragraph is saying that the amount of that debris that's on the key is actually quite a bit more than 65 other keys that are used on a daily basis, suggesting that this key was laying around somewhere collecting dust and then was potentially brought out for its purpose here to be used to plant in Avery's bedroom. So that's what's being said here. That's what it took me a minute to go through this, trying to suggest what they were saying about all this fine dust. That's what it is. That's what they're saying. It had too much on it, number one, and then it's obvious that it had, a lot of that debris on it, and that debris was pushed aside from when it was used once or twice. So very interesting. Next slide, please. Unless Tracie has any thoughts that she wanted to share.
No,
Okay.
not really.
Failure of trial defense counsel to present a DNA expert to establish that Mr. Avery's DNA was planted on the subkey by law enforcement. Ms. Halbach's subkey had Mr. Avery's complete DNA profile, but not Ms. Halbach's. The subkey found in Mr. Avery's bedroom is of much greater quantity than the amount of DNA Mr. Avery deposited on an exemplar subkey by holding it in his hand for 12 minutes. So basically, they did a little thing where Stephen held a key in his hand for 12 minutes, and the amount of DNA that he left on the key after holding it for 12 minutes was less than what they actually found on the subkey they found in his bedroom. So that's what they're getting at there. Stephen Avery's skin cells potentially came from his missing toothbrush is what her experts are basically suggesting happened. Next slide, please. Applicable law regarding exceeding scope of search warrant for Mr. Avery's DNA swabs violated the Fourth Amendment. The Fourth Amendment to the United States Constitution requires that a search warrant particularly describe the place to be searched and the persons or things to be seized. The Wisconsin Supreme Court has stated that the particularity requirement of the Fourth Amendment satisfies three objectives by preventing, number one, general searches, 2, the issuance of warrants on less than probable cause, and 3, the seizure of objects different from those described in the warrant. In United States v. Reich, the court found that the investigators did not confine their search in good faith to the objects of the warrant. In that case, the police entered the defendant's home, caught him flushing marijuana down the toilet, and obtained a search warrant for the marijuana. When they executed the warrant, instead of seizing the marijuana, they seized thousands of documents. The documents were suppressed by the court. Basically, so okay, so let's just go over that for a second. They went in, they got in a warrant to go in for marijuana. They went in, didn't touch the marijuana, grabbed a bunch of documents the guy had, and were intending to use those against him, and the court didn't allow it. In United States v. Medlin, the search warrant at issue identified firearms owned by the defendant as the items subject to the proposed search. In addition to the firearms seized during the search, hundreds of items not identified in the warrant were seized. All of the items were suppressed. Both Rettig and Medlin illustrate that a search conducted in flagrant disregard of the warrant's limits undermines the Fourth Amendment particularity requirement and requires suppression of all items seized, including those within the scope of the warrant. Any thoughts on any of that, Tracie?
It's pretty self-explanatory. They're basically just saying that you can't go on a fishing expedition on a search warrant.
Right.
You have to have a specific purpose. That purpose has to be listed on the warrant, and that's what you're going in there to look for. If you see something else, then you need to call a judge and get the warrant expanded on. Right. Broaden the scope of the warrant. But you can't just take whatever you want when you went in for a specific purpose.
Right. Next slide, please. Failure of trial defense counsel to detect and raise Fourth Amendment violation regarding groin swab taken from Mr. Avery, which exceeded the scope of the search warrant for Mr. Avery's DNA samples. 2 groin swabs were taken from Mr. Avery at Aurora Medical Center by a nurse on November 9th of 2005. Fassbender met Wiegert, who was escorting Mr. Avery for the examination. Mr. Avery was taken into an examination room. Towards the end of the examination, Fritsch, that's the nurse, took 2 swabs of Mr. Avery's groin area in direct contravention of the search warrant, which specifically restricted that DNA samples were to be taken from saliva and blood samples of Mr. Avery. There was no reference to groin swabs in the search warrant. Furthermore, according to Fassbender's report, Frisch disposed of the groin swabs. Fassbender's report is not credible because Nurse Frisch never mentions in her charting disposing of the groin swabs. Fassbender's report directly contradicts Mr. Avery's account of this examination as described in his affidavit. Contrary to Fassbender's report, Wiegert told Frisch that he would discard the swabs while Fassbender escorted Mr. Avery into a separate room to get his fingerprints. As Mr. Avery followed Fassbender and Frisch out of the examination room, Mr. Avery heard Wiegert tell Nurse Frisch to give him the groin swabs, and Mr. Avery observed Investigator Wiegert walk to the examination room receptacle as if to discard the groin swabs. Mr. Avery observed that Wiegert did not drop the groin swabs into the receptacle. It is therefore reasonable to conclude from this clear violation of Mr. Avery's Fourth Amendment rights that Investigator Wiegert planned to use the illegally seized groin swabs from Mr. Avery to plant Mr. Avery's DNA on other crime scene evidence. For instance, that's where they're saying there was label swapping of the groin of the hood latch swab. So they're saying that this one of these swabs essentially would have been relabeled as the hood latch swab, and that's how we get 1.9 nanograms of Stephen's DNA on the hood latch, for instance. So, anyways, next slide. Oops. Failure of trial defense counsel to present a DNA expert to establish that Mr. Avery's DNA was never deposited on the RAV4 hood latch. According to current post-conviction counsel's expert, Dr. Reich, the most common way for forensic evidence to be planted is by relabeling the forensic swabs, as I was just saying. The state claimed that Mr. Avery's DNA profile on the hood latch was the result of Mr. Avery opening the hood and touching the latch with his sweaty fingers. Boy, don't you get sick of hearing the word sweat when you look into this case? Anyways, current post-conviction counsel's DNA expert, Dr. Reich, oversaw experiments in which individuals touched a hood latch identical to the one of Miss Halbach's vehicle. The hood latch was then swabbed. The swabs were source tested for the presence of skin cells and analyzed for the presence of DNA. In 11 of the 15 experiments, no detectable DNA was present on the swab. So just for those of you who know, I have a video about this topic where I go through Dr. Reich's affidavit, and I lean very, very heavy on that particular experiment in the video, and I cover it very, very vigorously because I find it very interesting that they were getting less than a tenth of an anagram on 4 out of 15 tries, and somehow Stephen walks up miraculously leaving 1.9 nanograms, and it isn't blood from a bleeding finger. Yeah. Anyways, next slide. Dr. Dahan has expressed to a reasonable degree of scientific certainty based on his expertise in the area of fire and fire debris examination the following opinions. A properly conducted recovery would have involved more comprehensive photography of the burned bones in the burn pit and better documentation as to where the bones were recovered. The appearance of the remains as found is often critical to the reconstruction of a fatal event or to the destruction of a body. There was no assessment of fuels associated with the fire, other than describing the remains of steel belts and beating of burned vehicle tires. The undersigned has had extensive experience with the combustion of human and animal remains under controlled conditions, and I have had the opportunity to see some 50 or more unembalmed adult human cadavers exposed to a variety of real-world fires. Dr. Dahan wrote the book Kirk's Fire Investigation. Destruction of a human body by fire is a progressive process. So it's not something that happens quickly. It's you can't just walk up to a human body, throw some gasoline on it, throw a match, and walk away. All you're going to do is char some of the skin, the fire is going to go out, and the body isn't going to really burn. And that's kind of what I think that's getting at there. So next slide, please. Many of the bone fragments shown in Dr. Eisenberg's forensic anthropology photographs appear to be coated with a yellow or a tan soil or dust. Dr. Eisenberg reported that she rinsed some of the recovered bone fragments to allow detailed examination. Others bore charred residues of organic material in the cancellous or spongy structure within. Such damage can be induced by exposure to an open air fire of ordinary combustibles for 6 to 8 hours, or for shorter times, 3 to 4 hours, in a well-ventilated fire in a metal enclosure such as a burn barrel or an automobile trunk. Based on the author's experience in exposing adult human cadavers to the variety of fire conditions, it was observed that a metal enclosure confines the flames to maximize their exposure to the body. It reflects the heat from the fire onto the target within, and it generates radiant heat as the metal itself heats, adding to the total heat of the flux during the combustion of the body. It is this combined heat flux that occurs within a commercial crematorium, where the radiant heat from the fire brick lining and the sustained uniform flame contact from gas burners bring about a full cremation of an adult human body in 2.5 hours or less. So what it's saying is, obviously, there is the difference between an open fire and a burn barrel fire. Is the open fire, the heat can just escape in every direction except down. Literally. It can go sideways, it can go diagonally, it could go up, straight up, it could go, I mean, there's no 360 degrees, there's no limit on where that heat can escape. But when you have burn barrel fire, you are limiting where that heat can escape, and that allows that heat to build up and get hotter and in the area of the burn barrel, and then the only place it can escape is straight up, and so that creates a greater heat. So moving on to the next slide. The heat output of a fire largely fueled by an adult human body is limited, estimated to be on the order of that on a office wastebasket fire. The more massive tissues and bones require larger, more sustained fire to be consumed or calcined. This can be accomplished with the inclusion of a vehicle tire because it will burn energetically for extended periods of time. If a body is allowed to burn undisturbed to completion in either an enclosure or a well-fueled and ventilated fire, the larger bones will retain their relative anatomical position. The head, neck, shoulders, upper arms, humerus, spine, hips, pelvis, upper legs, femurs. The process of stoking a fire with additional lumber or stirring with an implement during its active burning will cause the mechanical destruction of the bones as they are calcined by the flames and often considerable displacement. It is in the opinion of the undersigned that the human cremains recovered and examined by Dr. Eisenberg were physically entirely consistent with cremation of an adult human body in a field cremation involving a sustained and restoked fire for an extended period of time. In tests conducted as part of FFDIC exercises, open field, roadside dump fires on flat ground, it is observed that the more massive portions of the adult anatomy, base of the skull, shoulders, pelvis, were charred but not reduced to calcined bone fragments in fires lasting 4 to 7 hours. But they did retain their anatomical relationship unless mechanically stirred during the fire. Important thing there is that he's saying that it looks like Teresa's bones were burned in an open fire, but it would have been impossible really for that to happen at Stevens in 4 to 7 hours because he was only out there for like 2.5 or 3 hours, with the fire that night, supposedly, according to the prosecution. So it's not enough time to really do it. So that's, I think, what he's getting at there. Anyways, it is the opinion of Dr. DeHaan that Teresa Halbach's body was not burned in the burn pit behind Stephen Avery's garage. Dr. DeHaan bases his opinion on the reported lack of anatomical continuity of the remains. The remains of similarly charred calcined fragments in burn barrels and other locations on the property, and the absence of more massive fragments that normally resist such exposure. Next slide. It is the opinion of Dr. DeHaan that someone transferred Teresa Halbach's bones to Stephen Avery's burn pit. The discovery of larger fragments outside the margins of the burn pit and finding human bone fragments with similar degrees of fire damage in numerous other areas, including burn barrels on site, is also consistent with the dumping of burned remains into the pit, with some rolling away. It is the opinion of Dr. DeHaan that the state's theory of the burning of Miss Halbach's body in an open-air burn pit behind Stephen Avery's garage from 7 p.m. to 11 p.m. on October 31st of 2005, a period of only 4 hours, is incorrect. Specifically, Dr. DeHaan states that the state's theory is not supported by physical evidence. Dr. DeHaan states that burning a body in an open-air burn pit takes 6 to 8 hours to accomplish to the degree I observed in Dr. Eisenberg's reports. It is the opinion of Dr. DeHaan that the state's theory was also incorrect in its assertion that the burned vehicle bench seat was used to fuel the burning of Miss Halbach's body. Next slide. It is the opinion of Dr. DeHaan that the state's theory was also incorrect in its assertion that burned bones were intertwined with metal belts, resulting from the burning of tires. From my review of these photographs and reports generated by law enforcement agents at the scene and Dr. Eisenberg in later examinations, there is nothing to suggest that the tires were, in fact, burned with the human bones recovered in Stephen Avery's burn pit in the manner described by the state. Next slide. Failure of trial defense counsel to present a competent forensic anthropologist to establish that the bones in the Manitowoc County pit were human. And that's something that's getting talked about a lot right now, isn't it, folks? You know? So anyways, current post-conviction counsel has retained Dr. Symes, a renowned forensic anthropologist who has worked extensively in the areas of human skeletal biology and skeletal autonomy, forensic toolmark fracture pattern interpretation, including most aspects of trauma to bone, sharp force trauma, special expertise in knife and saw marks in bone, ballistic trauma, healing and acute trauma to bone, peri versus post-mortem influences on bone, blunt force trauma, and burn bone trauma. Dr. Symes was the recipient of the 15th Dale Stewart Award, which is a Lifetime Achievement Award recognized by the American Academy of Forensic Sciences and Anthropology section. So he's like a dude. He's like Bones, but he's a dude. Anyway, sorry. Couldn't resist. Dr. Symes has offered the opinion to a reasonable degree of scientific certainty in the field of forensic anthropology that a microscopic examination, if performed in 2005, would have determined with a high percentage of accuracy whether the pelvic bones found in the Manitowoc County gravel pit were human in origin. Histological slides, if made in 2005 from the suspected human pelvic bones, would have determined with a high percentage of accuracy whether the pelvic bones found in the Manitowoc County gravel pit were human. Next slide. Dr. Symes opines that it was below the standard of practice for a reasonably well-qualified and competent forensic anthropologist such as Scott Fairgrieve, the defense expert, to have relied exclusively upon photographs of the pelvic bones to complete his forensic examination. If trial defense counsel had obtained a competent forensic anthropologist who had performed a microscopic and histological examination of the suspected human bones found in the quarry, it would have conclusively established that Miss Halbach's bones were transported to Mr. Avery's burn pit from another site. Next slide. Failure of trial defense counsel to conduct a simple experiment to establish that Mr. Fabian's testimony was false regarding the smelling burned plastic coming from Mr. Avery's burn barrel. The burned electronic components which belonged to Miss Halbach were not found in the first searches of Mr. Avery's property. Mr. Kratz was involved in directing the search of the burn barrels. He knew that the electronic components of Miss Halbach were not in Mr. Avery's burn barrel in the initial searches, but then miraculously appeared on November 7th of 2005. The state's only witness used to establish that Mr. Avery burned Miss Halbach's electronic devices in the burn barrel on October 31st at dusk was Mr. Fabian. A series of experiments conducted by current post-conviction counsel's investigator has established that Mr. Fabian committed perjury when he testified about smelling burnt plastic emanating from Mr. Avery's burn barrel. Trial counsel failed to rebut Fabian's very incriminating testimony about seeing thick smoke and smelling burning plastic by doing their own experiments to disprove his statements. A Canon PowerShot A310, the same camera issued to Miss Halbach by AutoTrader, was burned at a high temperature than possible in Mr. Avery's burn barrel to determine whether it would emit a detectable odor of burning plastic. Again, there was no detectable odor of burning plastic or any heavy smoke emanating from the fire. Next slide. So once again, asking yourself, why are you here? Next slide. I like that picture of Stephen too. So, once again, any questions you have, I know this was a lot of stuff we threw at you today. Any questions you have, remember, if you didn't write it down, go back and rewatch this. Find the slide number, the paragraph number, to help Tracie and Travis and I when we do the live. to do the live Q&A about this. Make sure you have the slide and the paragraph numbers to help us more effectively answer your questions. Tracie, before we head out, is there any thoughts you'd like to offer about what we covered today?
No, I think I jumped in with wherever I wanted to add something. I think she makes it pretty easy to understand and lays it out so that it's pretty straightforward, and that everyone should be able to understand at least what she's trying to present and what she's saying, where they went wrong in their defense.
And you would agree with Travis's assessment that defense lawyers are, that when they're in a situation like Dean and Jerry are, where their client has a new lawyer that's trying to go, make moves for post-conviction relief, that they are really willing to, take the blame, take the fall, to a certain extent, for their former clients. That you would agree with that?
For the most part, yeah. Not always, but yeah. I mean, it depends on the lawyer.
Right. But as we all know, that the Dean and Jerry are taking that attitude, fortunately. So.
Yeah.
So, okay. So, folks, this wraps up Ineffective Assistance of Counsel, Part 1. We got one more that's going to be following this one. Because like I told you, this is a huge section. It's the biggest section in the motion for post-conviction relief. It's the one she's pounding on the hardest. So, we're going to be moving into Part 2. Keep your eyes out for that. It'll be coming shortly after this one. And if you haven't already, please hit subscribe, and we'll see you. Big hand for Julie, by the way, everybody. All right, so that's going to wrap up Ineffective Assistance of Counsel Part 1. Big shout out, Julie J. Man, she is totally killing it making these slideshows that makes all this stuff more easily presentable and everything. So big hand for Julie J, everybody. Big hand. Thank you to Tracie Strunsey for being here tonight to help fill in, because Travis was pretty busy with something important. So she was absolutely stellar to step in kind of last moment's notice. Stepped in and pitch hit for Travis, which was awesome. Thank you so much, Tracie, for that. And for all the supporters out there, for everybody out there creating the interest in this, creating the awareness in this, and all that sort of stuff, keep it up. And look forward to Part 2 of Ineffective Assistance of Counsel coming tomorrow. If they haven't already, please hit subscribe, and we'll see you.
My name's Stacy Seabrook, and I approve Eric Jose on Making a Murderer to be able to use my songs on his channel. Thank you. So let's keep talking about Avery. Yeah, let's keep talking till he's set free. Oh, you just listen, I think you'll see why it matters. Oh, really matters. Put aside the documentary, the state's version ludicrosity. Oh, all their claims so blatantly get torn to tatters. I think that matters. I bet you heard about her latch sweating, but maybe you ain't heard this yet. 19 more times the DNA that was left anywhere else that day. I think that matters. I really do, I think it matters. An ex-boyfriend with a day planner page, and yet they did not investigate. And who knows why, and who can say why he was signed into the crime scene that day. I think that matters. I really do, I think it matters. about the barrel that once was seized, but then returned to the Averys. The bones were found the next day, but not one photograph exists of where they lay. I think that matters. I really do, I think it matters. I could go on listing things off, 80 more things. I just keep on singing these songs till every freedom rings. I said it matters. It really, I know it matters. It could be you, I think it matters. It could be me, I know it matters. Work with KZ, it matters. I said it matters. It really matters.
He's innocent. The day always comes if you're innocent.
Get on the train before it leaves the station. Wisconsin versus Avery, a complete fabrication. Get on the train before it leaves town. The truth train is coming, gonna run them down, run them down. And we all know Stephen and Brendan were blamed, but it does not take a brain surgeon to see that they were framed. And yes, we know what this was about. The civil suit, the settlement they did not want to pay. I want to pay out. And you may hear this song, or maybe you don't get it. I suggest you look up TikTok, Manitowoc on Reddit. There you will find trial transcripts, evidence files, and reports. And you will start to fathom the corruption within the courts. And as you shake your head because everything seems demented, you will find yourself in company of 3 on-bank judges that dissented. But don't you worry, you're not going insane. You just happen to sit down on Zellner's Truth Train. Get on the train before it leaves the station. Final destination, inevitable exoneration. Get on the train before it leaves town. The truth train is coming, gonna run them down, run them down. Get on the train